Okay, learning objective 3 deals with liability to third parties. And specifically, we're still talking about common law here, liability to third parties. So before we can go too far, as it relates to third parties, we have to talk about different types of third parties. So there are three general categories of third parties. You have primary beneficiaries, it's called foreseen third parties, and then foreseeable third parties. And in terms of their relationship to the auditor, primary beneficiaries are more known to the auditors, and as you go down, they're less and less known to the auditors. So a primary beneficiary is an individual or a company or group, whoever, that is known by name to the auditor. That is, they're known to want to use or that they are going to be using the audited financial statements. A foreseen third party is similar, except for now it's loosened. It's a more broad general category of people. So it's not an individual who's known by name to the auditor, but it is a party that could reasonably be expected to use the audited financial statements. A foreseeable third party is the most general class. It's parties whose decisions we would expect to be influenced by the audited financial statement. So as you move from primary beneficiaries down to foreseeable, again, it's expanding the scope of the auditor's liability with regard to the financial statements. So, what are some examples of these different groups? If a client came to you and said, I need my financial statements audited because I'm going to go to Bank of America to get a loan. Bank of America is a primary beneficiary because they're known by the auditor, and the auditor also knows that they are going to be the ones that receive the audited financial statements. An example of a foreseen third party would be a situation where the client comes to you and says, hey, I need my financial statements audited because I'm going to go to banks to get a loan. So I'm going to submit these to several banks to try and get a loan. In that scenario, you don't know which specific banks necessarily, but you know that banks in general are going to be receiving these audited financial statements. A foreseeable third party, again, this doesn't have to be known at all, really, to the auditor. It really is an interpretation in terms of uh, whether you would expect someone to actually use these audited financial statements. And that's really kind of in the eye of the beholder. It's really the interpretation of the judge or whoever's making that decision as to who would be considered foreseeable. So there's some general groups of people that we would probably expect would look at financial statements, right? Analysts, investors, but it's still subjective. Who exactly do you expect use audited financial statements? And so it really, as you move down, it becomes more and more subjective in terms of uh, what category an individual falls into. So, why is that important? As it relates to liability to third parties, the only reason why those distinctions are important is, is because an auditor has different liability for ordinary negligence to these different groups. So that's the only time that the distinction between third parties is important, is as it relates to the auditor's liability for ordinary negligence. With gross negligence and fraud, an auditor is generally liable to anyone that they've harmed. So it doesn't matter whether they're a primary beneficiary, foreseen, foreseeable. For those, you're going to be generally liable. So these distinctions are only applicable to considerations of ordinary negligence. So if you're doing a problem and they're talking about constructive fraud or fraud, it doesn't matter whether they're primary beneficiary. It only is important if we're talking about ordinary negligence. So Liability for ordinary negligence. By far and away, the most important case related to ordinary negligence is Ultramares. And Ultramares basically found that ordinary negligence is insufficient for liability because of lack of privity. That is, there's no contractual relationship between the third party and the auditor. And so, what that's really saying is third parties under Ultramares cannot sue an auditor for ordinary negligence because they do not have a contractual relationship with the auditor. And again, subsequent cases have clarified that auditors are generally liable to everyone for gross negligence, constructive fraud, and fraud. So again, these are only important in terms of looking at ordinary negligence. Now, that was the initial ruling, that was the initial case law. A subsequent important case that expanded the auditor's liability is Credit Alliance v. Arthur Andersen. And this is the case that set precedent for liability to primary beneficiaries for ordinary negligence, provided that certain conditions were met, that the auditors were aware, that the third party was specifically identified, and that the auditor somehow acknowledged of the intent of that third party to rely on the opinion. So that's a very important case because it expanded it beyond just liability to the client for ordinary negligence. It expanded it to primary beneficiaries. Rush Factors v. Levine subsequently expanded the auditor's liability to what are called limited and identifiable foreseeable parties. So this is really where foreseen third parties first started having some kind of precedent to bring a liability case against an auditor for ordinary negligence. And Rosenblum v. Adler is the case that set precedent for the most general liability of auditors to third parties for ordinary negligence, which made them liable to an unlimited class of all foreseeable third parties for ordinary negligence. So the question you may be asking is, do I need to know all these? And the answer is kind of. You know, the big ones that you guys need to definitely know are Ultramares and understand what Ultramares means in terms of auditor liability. As far as Credit Alliance, just understand that that's an important case because it kind of broke up the Ultramares doctrine a little bit. And Rosenblum v. Adler is important because it essentially negated some of those earlier precedents. Now, is an auditor liable to only their clients for ordinary negligence, or is it foreseeable third parties? And the answer is it depends, right? It depends on how narrow the judge that you get is going to interpret the case law. If they have a very narrow interpretation, they're going to follow Ultramares or Credit Alliance and say, hey, at best, you have to be a primary beneficiary. However, they can follow Rush Factors v. Levine, or they can follow Rosenblum v. Adler. So it really depends on the judge that you get and how they interpret the case law in terms of whether the auditor is liable for ordinary negligence to a third party. But understand that in terms of the CPA exam, the big ones that they're going to look at are the Rosenblum v. Adler and the Ultramares. They want to make sure that you understand that those are the important cases that really set the case law, but they're also going to test whether you understand that these distinctions that we're making are only important with regard to ordinary negligence. So a lot of times they'll give you all this build up and talk about all these different things, but what the person is suing for is, say, fraud. And these things don't matter if we're talking about fraud. So make sure that you know both the case law and also understand when to apply this. And that's only in ordinary negligence cases. So then the next question is, well, okay, let's ignore that and say that they are bringing some case for ordinary negligence, constructive fraud, and fraud. What do they have to prove? And the good part about this is it's the same thing that clients have to prove. if they're bringing a common law tort case. For ordinary negligence, they need to prove duty, breach of duty, proximate cause, and injury. So the exact same things that we saw before. And for constructive fraud and fraud, it's the same thing that the client has to prove. So if you remember back for constructive fraud, it was mystery, right? Because constructive fraud deals with recklessness. So it's material misrepresentation or omission, recklessness, reliance, and injury. And fraud is the same as it was for the client. It's misrate, material misrepresentation or omission, scienter, reliance, and injury. In terms of the defenses, they're essentially the same with one notable exception. First, lack of duty. So again, saying that the third party has no standing in terms of bringing a case. And this is particularly useful, as we were just talking about, in terms of ordinary negligence. Say, hey, we don't even have a contractual relationship, so there was no duty of care that you should have expected from me. Non-negligent performance is always an option. Causation is saying, oh, yes, you suffered a loss, you suffered an injury, but the injury was not because of something that I did. It's because of something that someone else did. Now, the big exception in terms of common law liability of third parties is contributory negligence. And that is not available for suits brought by third parties because it's generally assumed that a third party is not in a position to contribute to materially misstated financial statements. When we're talking about a client, that makes sense as a defense because you can say, you created the financial statements, so you're at fault. But if we're thinking about what a third party is, it's someone outside the company. How could they create the misstated financial statement? So it's not an available defense. So in terms of a summary, liability to clients, again, breach of contract, ordinary negligence, gross negligence, and fraud. Liability to third parties, it's essentially the same, the big difference being they're not going to be suing us for breach of contract. It's going to be tort liability, gross negligence, constructive fraud, and fraud. And again, tort liability is going to be limited for ordinary negligence depending on the court's interpretation of the case law. Okay, so let's go through some examples of applying these concepts. If a stockholder sues a CPA for common law fraud based on false statements contained in the financial statements audited by the CPA, which of the following, if present, would be the CPA's best defense? And the answer is going to be B, that the false statements are immaterial. So why is that going to be the best answer? And if you think about someone bringing a case for common law fraud, you say, well, what do they have to prove for fraud? The very first thing that you have to prove is that it's a material misrepresentation or omission. So if they can't clear that hurdle, then they're not going to be successful in the suit. In terms of lack of privity, that's not a necessary element if someone's suing you for fraud. The CPA not benefiting financially is not an available defense. And contributory negligence on the part of the client, you could argue that, but it's not a necessary element of proof by the person bringing the defense. And so B is going to be the better answer. You can argue contributory negligence, but B is going to be a better defense than D. Hark, CPA failed to follow generally accepted auditing standards in auditing Long Corp's financial statements. Long's management told Hark the audited financial statements will be submitted to several banks to obtain financing. Relying on the statements, third bank gave Long a loan. Long defaulted on the loan. Of course they did. And in a jurisdiction applying the Ultramarines decision, if third sues Hark, Hark will. So this is, you can tell an accountant wrote this. So third being a third party, is suing the auditor. So you have some third party suing the auditor. And the important sentence here is the very last one. In a jurisdiction applying ultramarines, if a third party sues Hark, which is the auditor, Hark will, and the answer is Hark's going to win because there's no privity between Hark and the third party. So A is the answer. If a CPA recklessly departs from standards of due care when conducting an audit, the CPA will be liable to third parties who are unknown to the CPA based on, so again, you see reckless, you should say gross negligence and or constructive fraud, either or. Under common law, which of the following statements most accurately reflects the liability of a CPA who fraudulently gives an opinion on an audit client's financial statements? So again, they're talking about fraud here, and the best answer is going to be C. The CPA is probably liable to anyone. So again, when we're talking about fraud and third parties, saying, oh, only foreseeable or privity, all those things are not important. The important thing to remember is fraud is some kind of intent to deceive. And in those cases, the auditor is going to be liable probably to anyone who is hurt at all. Which of the following is the best defense a CPA firm can assert in a suit for common law fraud based on its unqualified opinion on materially false financial statements? So, what is the best defense for being sued by fraud? Well, you need to figure out a way to chip away at what the third party or the party that's bringing the suit is going to have to demonstrate, which is Miss Re, right? Material, scienter, reliance, and injury. So D would be a great answer, right? If you can prove that there was no intent, that's one of the necessary elements of proof that someone would have to demonstrate to be successful in that type of a suit. So D is going to be the best answer. And that is it.